Welcome back to an interesting case. Today we're going to have another sort of free form case because I'm still having some trouble getting back into the old format of writing everything out in a blog, so I apologize. I do intend to do that at some future time, but at the moment, due to difficulties, I'm just going to be doing this free form. Today we're going to be revisiting the Stinchcombe disclosure case because that video seemed to be of interest to a number of people. And specifically, I'm going to talk about how Stinchcombe disclosure applies to administrative law. The Stinchcombe disclosure case came up in the 1980s, and it was to do with a criminal case tried in the traditional court system where a lawyer was charged with misappropriating funds, that being Mr. Stinchcombe. And when he was charged and prosecuted, the prosecutor decided that he would not provide Mr. Stinchcombe's defense lawyer with some of the evidence that the police had collected, because, in the prosecutor's opinion, the witness in interview, which was the evidence in question, was an audio recording of a witness being interviewed. That witness was not reliable. It wasn't good evidence, and so he refused to hand it over. He wasn't going to use it in the trial, and the prosecutor thought that it wasn't, relevant in the prosecutor's opinion. Up until that point in Canadian law, there had not been any clear rules for what evidence the prosecutor had to disclose to the defense. The prosecutor would disclose information to the defense, but it was up to the prosecutor how much and what to disclose. Then, because of this case, the Stinchcombe case, where Mr. Stinchcombe fought the matter all the way up to the Supreme Court of Canada, the Supreme Court of Canada came down with the rule that is often referred to as the Stinchcombe disclosure rule, that the prosecution has to hand over basically all of the evidence to the defense, even if the prosecutor doesn't think it's, in his opinion, good evidence, and even if the prosecutor doesn't intend to use it. He has to hand over basically all of the information that the investigators came up with, unless something is very clearly irrelevant, and there's a very low bar for what is considered relevant. So basically, everything has to be handed over. Um, there are a few exceptions, but as a rule of thumb, everything gets handed over. Now, other cases have come up in non-traditional formats, outside the traditional court system, and the question comes up: well, what does the government have to hand over to a defendant or an accused person when they're being prosecuted or dealt with in these other new formats? For example, there are a number of administrative tribunals that are used across Canada. There's tribunals for rent disputes between, landlord and tenants. There's tribunals for immigration disputes. There's tribunals for for various professions, like people, doctors and lawyers, if they're accused of some kind of misconduct under a professional code of conduct. So, and in from my background, working in municipal bylaw enforcement, there are these days a number of bylaw tickets that are handed out for violating municipal bylaws that are dealt with outside the traditional court system by, in British Columbia, they're referred to as adjudication hearings. Um, and they're dealt with by officials called adjudicators appointed by the province. These are not part of the traditional court system, and they do not have all the same rules and procedures of the traditional court system. So, what do people have entitled? What entitlement do people have to disclosure in these settings? Well, you have to look to other cases, um, like May versus the Ferndale institution, which was a Supreme Court case which dealt with um, uh, some inmates that had their security classification changed against their wishes, and other cases like Baker v. Canada, which was a citizenship and immigration case dealt with by the Supreme Court. But if you sort of merge all the case law together from these various cases, you see a general rule that, um, when you're dealing with administrative law and administrative tribunals and administrative decision makers, the standard of disclosure is lower. the prosecutor or the government who is charging or accusing a person with something or taking some kind of enforcement action, if it goes to a non traditional court system, they don't have to disclose everything that they would in the traditional courts. The disclosure bar is lower. Now, that doesn't mean that the accused person has entitlement to nothing, but it is a lower entitlement. And there's some interesting documentation put out on this. I'll have it's cited in my references. It was a PowerPoint presentation I came across from the Law Foundation from their 2020 conference, and it kind of puts out in point format procedural fairness in administrative hearings, and it's a pretty good summary of what the requirements are. Um, Basically, if you're dealing with an administrative hearing of some kind, like a bylaw adjudication hearing, or some kind of, you're appealing something to your local city council because there's a decision you don't like, you're not entitled to all the information. The basic standard, the rock bottom kind of level of what you're entitled to under natural justice rules is you're entitled to be heard, and you're entitled to a fair decision made by fair decision makers who give you reasons for their decision. On top of that, there may be the more serious the decision is, the more you're entitled to. For example, if they're possibly taking away your ability to work in a certain occupation, you'll be entitled to more disclosure. If it's a less serious decision that affects you less, you will be entitled to less. But yeah, so there's a sliding scale of what kind of disclosure you're entitled to. Um, that's basically all I have for today. I might get into this further in another video in the future, but again, I apologize. I am somewhat limited for time. So that's where we end today. I hope you found it useful. I hope you found it interesting. If you did find it useful in any way, please consider giving the video a like and a comment. Thank you, and take